Good morning, everybody. Okay, welcome to our webinar, Protecting Your Scheme Against Misappropriation. Thank you for joining us. We actually have a lovely turnout this morning, so we're looking forward to getting started. Just before we begin, we're going to put up a quick poll for a minute or two while the others are still joining. It's just a quick poll so that we have a better idea of who our audience are for the day. So I'm going to put that up now. There's just 2 questions. If you could click on each of those, that would be very helpful. Thank you. Okay, super. I'm going to go on to the second question. Thank you. Super. So it looks like we've got majority managing agents, trustees. Thanks very much. Okay, just introduce our 2 guest speakers for the day. Willie Roos from StrataFin and Deborah Val from the PPRA. Just a quick intro. Willie Roos is the founder and CEO of StrataFin. He holds BCom and BProc degrees from the University of Johannesburg. He practiced as an attorney and conveyancer until 2008, whereafter he became involved in sectional title management. During his time as the principal of a managing agency and dealing with the financial difficulties and woes of many schemes, Willie became interested in community schemes financing and started working on the business and actuarial model on which StrataFin is built. In 2012, Willie, together with his business partner, started raising capital necessary to operate a funding business in the community scheme space. And in 2014, they launched StrataFin. Today, StrataFin has assisted hundreds of schemes throughout South Africa and have placed funding exceeding 300 million into the hands of schemes. StrataFin set out to change the way schemes are assisted during times of financial crisis. And they were the first company that provided finance to schemes without the obligation of the scheme to repay the finance received and without catching them in the debt trap. In the last 10 years, as the CEO of StrataFin, Willie has been involved in all aspects of community schemes, from financing to training to professionalizing the industry and more. Willie has been a speaker at various NAMA and CSAS events throughout the country and regularly runs webinars for managing agents and trustees on the StrataFin YouTube platform with other industry leaders and service providers. Willie has strived to bring knowledge to community schemes and scheme executives and has launched the free trustees training portal on the StrataFin website under the multimedia page. Our guest speaker for the day, Deborah Val from the PPRA. Welcome, Deborah. Deborah Val has been thank you. Deborah Val has been an advocate of the High Court for 38 years and is currently the Fidelity Fund Claims Manager at the PPRA. She holds a BA Law and postgraduate LLB degree. She began her career as a public prosecutor and has spent many years as a magistrate with the Department of Justice, presiding in the criminal and civil courts and in the regional court where required. She then entered the world of private practice and spent 11 years as a practicing advocate specializing in litigation, contract and property law, insurance law, arbitration, mediation, and governance. After joining the PPRA, she has acted in various departments at the PPRA in executive and management capacities and has become an expert in the new Property Practitioners Act and regulations. She's assisting the authority and stakeholders to navigate the legislative changes and the consequences for community schemes, managing agents and stakeholders of financial malpractice and misappropriation. Deborah has participated in training, webinars, and speaking engagements nationwide to sensitize and inform community schemes and estate agents of important aspects of property law and the financial consequences of legislative non-compliance. Thank you so much, Deborah, for joining us, and we look forward to hearing more.
Thank you.
Good morning, everybody. Thank you for joining us. We are very honored to have you guys here, and let's get going. We've got, I think, 16 points that we discuss in how schemes can protect themselves against misappropriation, and in general ensure that their finances are run properly. So I think we need to start with the introduction to the importance of safeguards against funds, against misappropriation. And I think, Deborah, you can start by discussing fidelity claims and how that works at the PPRA.
Certainly, thank you very much. Good morning, everybody, and very honored to be with you today, and very grateful to Willie for inviting me to give you some information on the Property Practitioners Fidelity Fund and how it affects you and how we can assist you to ensure that you would have a claim where there is a loss and to know under what circumstances Fidelity Fund would not be available to you. So I'm going to start off in discussing the importance of safeguards, which Willie has touched on, simply because we always need to be aware that whatever our circumstances, when we have a loss, whether we can recover or not depends on legislation. It depends on conditions, it depends on what we have complied with, and it depends on what the Act says is covered by the Fidelity Fund and what is not. So it's very important that we're aware that in some instances we may not be able to recover, and therefore safeguards are very important. We should also be aware of the serious consequences where we fail to take appropriate safeguards in protecting a fund's money. And the reason, of course, for that is that it can have a catastrophic effect on your body corporate, your community scheme. And we've seen it so often in dealing with Fidelity Fund claims, where there's been a managing agent who has misappropriated funds belonging to a community scheme, wiped out the entire maintenance account, very often the current account as well, paid for a flight to Australia and never to be seen again. And we have a community scheme that cannot pay the electricity account, cannot pay their staff, and find themselves in dire straits. Now, Fidelity Fund claims are limited by statute. So it's important that we know how we can comply with statute and how the Fidelity Fund assists us in terms of those statutes. Some of the reasons and examples as to why we would need to know information and ensure that we are compliant is that we need to remember that there are various items which we have to comply with if we are going to be safeguarded by the Fidelity Fund. And this includes things like compulsory statutory insurance, which if it's not in place, we would find ourselves in a difficulty because the Fidelity Fund administrators may very well say, well, we have a defense against your claim because you were guilty of contributory negligence, or the cause of it was your own negligence to some extent, and therefore your claim may not be paid at all or in full. The other aspect is that managing agents are at risk of serious disciplinary action by the PPRA, where there are no controls to prevent misappropriation. And this is where principals might find themselves in hot water, where they rely on staff to actually perform certain transactions on bank accounts, and they don't keep a proper oversight in that regard. Other issues which we need to be aware of is the fact that fiduciary liability for directors and trustees is also a very scary option, which you don't want to become applicable to you. Directors may, in some instances, claim personal liability where they have failed to act in their capacity as a director with the proper safeguards and due diligence. Managing agents, of course, need to be aware that accountability cannot be delegated, and especially this happens in relation to trust accounts. So please be aware that the fact that a managing agent might have more than one principal, might have senior staff who are in control of trust monies or have access to transact on trust monies, does not mean that they are no longer responsible for that money. And I always mention the case law in this regard because there was one particular case which we need to remember, and this one had very serious results for an attorney who was in partnership with another attorney. As you know, the attorney trust account provisions are very similar to the property practitioner trust account provisions in our Act. And in that particular instance, one of the attorneys did all the day-to-day court work, did all the running of the business, and the other one dealt with the trust account and the finances. That particular attorney decided to steal all the trust money and abscond overseas and leave behind his partner, who had very little input into the finances. The partner attorney was sued for malpractice, and an application was brought to the court for him to be struck off the roll of attorneys. His response to this, of course, was, well, I didn't steal anything. I actually had nothing to do with the trust account. And it was not me, it was my partner. And the response of the judges at the time were, well, that's exactly the problem. The fact that you had nothing to do with your trust account is exactly the problem. You should have been safeguarding it, you should have been checking, and the fact that you didn't means that you were grossly in dereliction of your duties, and he was struck off the roll of attorneys. So managing agents, let's learn a lesson from that and be aware that we cannot delegate that responsibility and that accountability. We will always be held accountable for those trust monies, and the PPRA will obviously take action, and you don't want to lose your business, your Fidelity Fund certificate, and your right to operate simply because of somebody else's actions.
Deborah, if I can quickly jump in here, I see that Clive raised an interesting question, or he made a comment in that regard, and that is specifically that the Fidelity Fund is applicable where the money is in a trust account. So it actually has to be in a trust account, alternatively, as the rules require, into a account which is in the name of the body corporate. And is actually the body corporate's account. So so if it's not in a trust account, but it's just in some or other random account, then obviously there will not be a claim at all. So trustees must make sure that the account is an appropriate account in accordance with the Act.
Thank you. All right, the Property Practitioners Fidelity Fund was created by statute, and it's found in Chapter 7 of the Property Practitioners Act. Section 34 and following deals with all the various aspects of the Fidelity Fund and the circumstances in which you can claim for money which is lost. Now, the purpose of the fund is to reimburse persons who suffer pecuniary loss due to the misconduct of a property practitioner, which is due to, and there are two specifics that are set out here. One is the theft of trust money, and the other is the non-compliance with Section 54.1 or Section 54.3. And for those who are not familiar with the new Act, Section 54.1 and 3 are those sections which refer to the property practitioner's duty in all circumstances to open a trust account and keep trust money in that trust account until such time as they are lawfully entitled to pay it out. So the theft which we can assist you with in the Property Practitioners Fund is theft of trust money and the loss of that trust money where it is occasioned by the fact that the property practitioner failed to place it in a trust account registered in terms of Section 54(1), or he failed to keep it in that trust account. Instead of doing so and then paying it out when he was lawfully entitled to, he decided to draw it out and use it for a trip to Mauritius, or to use it to pay his office telephone account or whatever. Right? So we need to be aware that the only kinds of claims which the Fidelity Fund deals with is these particular losses. So you cannot claim against the Fidelity Fund for any losses which arise from damages due to the negligence or non-compliance of a managing agent with any of the duties which he has or is supposed to carry out under his mandate. Any breach of contract issues, any losses arising from that are not covered by the Fidelity Fund. So a claim arises where trust money is stolen by the property practitioner or lost due to those circumstances. But this is also conditional upon a number of things. One of them, and most important, is that the managing agent was in possession of a Fidelity Fund certificate at the time of the transaction or at the time of the loss, and that the principal firm as well as the agent, managing agent, were so in such possession. So each has to have a Fidelity Fund certificate for that claim to be valid. And that is included in the new Act. It wasn't in the old Act, but it's very specific in the Act and the regulations. There are other obligations which need to be complied with. And we should remember that any defences which are available to a property practitioner against a claimant would also be available to the Fidelity Fund. And so we are obliged to protect the Fidelity Funds in whatever way we can in terms of the law, and we are obliged to apply the law. So if there is such a defence, you may find that it is raised where a claim has been submitted. Remember also that the Fidelity Fund might have a right of action against the principal to recover for the theft of his employee, and where there has been contributory negligence on the part of somebody which has led to the loss, the PPRA could also proceed to action in that regard. Remember what contributory negligence might be for purposes of trustees, for purposes of principals or directors, and that is any failure to comply with a duty which you have, a duty of care or a statutory duty which you may have as a result of your position and in your official capacity. And also, non-compliance with any of the statutory requirements could also give rise to a contributory negligence situation which might affect your ability to claim. Now, in terms of the legislative requirements to claim, we have touched on the Fidelity Fund certificate. It's also required by law that the claimant lay criminal charges against the perpetrators and is also obliged to cooperate with the PPRA and any organ of state in prosecuting or pursuing the persons who are responsible for the theft or loss. It should also be remembered that your claim only arises where the trust money was paid to the property practitioner as trust money in his capacity as a property practitioner. So if there's some kind of personal agreement between you which is not in his capacity as a property practitioner, that would not fall under the provisions of the Act. We've mentioned the fact that it must be trust money, and trust money is actually defined in the new Act, and it sets out exactly what it is. So we no longer have to rely on any common law definition or case law as to what trust money is. Those will obviously be persuasive where there is a dispute, but the trust money is actually defined in the definitions of the Act. So you can have a look at that. It is fairly lengthy and involved, but it's quite simple if you have a look at it and read it carefully. I think that will give you the information. As far as the process in filing a claim against the Fidelity Fund is concerned, it's very simple. you are required to lodge a complaint online. On the website of the PPRA, you will find that there is a button which you can use, which is called Lodge a Complaint button, and you press that, go in and continue to fill in the forms that you need to, and to attach any documents in support of your claim. There is a preliminary investigation when this is received by the legal department to check that it is in fact a complaint under the Act and that we have jurisdiction over it, and where it contains a claim, and this you need to specify in your application, that it is not only a complaint against the estate agent or the managing agent, but it's also a claim against the Fidelity Fund, and in that instance it will be sent to the claims department, where you will be contacted with a claims number, the name of a claims officer who is dealing with your matter, and you may be asked for claim documents in order to substantiate your claim if you haven't attached them. And the kind of documents we need are documents which are the contract on which the loss was based on, in other words, your contract of sale, your contract of management, your mandate, whatever it might be. There may be invoices that were issued. We have to have proof that payments were in fact made to the property practitioner. We also have to have proof that the money was actually collected by the property practitioner or the managing agent. And once we have all of that, the claims officer will compile a claims pack, which goes before the claims committee or adjudicator for approval. If they have any queries or they want anything further, they may request it, which will lead to delays in the matter. And once the claim is approved, payment will be made on receipt of the payment documents, which we will ask you for. So that's basically the process that is followed. There are times when the claim is delayed quite substantially, and that's usually in cases where we've had to appoint a curator in order to take possession of the trust account and the trust monies, which may have been held by the managing agent or the perpetrator of the theft. And the curator then would have to go through compiling a curator's report, how he distributes the money, whose money it is. It's a very long process. Also, where we have liquidation proceedings, where the managing agent or the company in question or person in question has been liquidated or sequestrated, that also means we have to wait for that to be finalized. As in the recent case, which we have just before us a moment, where we've got a huge number of claims in a theft by a very large managing agent company, we have in fact gone further, and our curator is conducting an interrogation under the Companies Act, Section 415, for us to find out where the money has been used or hidden, what the directors' activities were, what we can recover from the directors personally, if anything, and where we can actually find and access the money. So those, of course, are very expensive for us, and they take a lot of time. So that sometimes causes delays. Claimants need to remember that money is paid out according to statute, according to legislative requirements and court processes. So where we do these things, they have to go to courts, they have to go through court processes. We cannot simply decide we're going to do this, that, or whatever. In order to resolve claims, we have to follow the correct constitutional procedures and civil action. So that is why sometimes it does take time. We then receive and consider curators and liquidators' reports in order to see whether any of the claimant's claims were paid out from the money that was realized in the estate or in the trust account. And we then obviously will consider a claim for the balance in the Fidelity Fund. So it's very important that we all maximize our chances and our clients' chances to recover if necessary, and we ensure that statutory compliance exists in relation to proper governance and control. Specifically, trustees, new managing agents who take over where money has been lost under the under the auspices of a previous managing agent, it's absolutely essential that you have source documents to provide us with. Many community schemes have been unable to claim because what they have done is they've said, right, this is how much money we should have got in relation to levies, etc. This is how much we actually got in according to our audited financials, and so our loss is X. Now, that is of absolutely no value in proving a claim, because that doesn't prove that that money was collected by the managing agent, doesn't prove that it was trust money, and as a result, the claims committee would not find that is sufficient proof for the claim to be successful. So it's absolutely essential that you have the source documents and you can say, right, we have on a monthly basis requested bank statements from from the managing agent in respect of our accounts, and we have them and we can see exactly what was paid into that account. We can see what money was paid out of that account, and we can provide it for purposes of proving our claim. So that's very important. But don't delay in that regard, and make sure that you investigate any discrepancies quickly, and so that we can get that explanation where we find any discrepancies in the quantum of a claim. It's very important to note that if a scheme, a community scheme, retains its money in its own account and not in the account of the managing agent, that money is not in the possession of the managing agent, even where the managing agent might have transaction rights on it, and that money is not covered by your fidelity fund. So please be aware of that and ensure that when it's in your name, you organize and arrange your own controls in respect of that account to ensure that your managing agent does not have unfettered access to that account and the money is contained in that account. Just to finish off then, there's one particularly important compliance issue which managing agents should be aware of and which trustees and directors of community schemes must be aware of, and that is the need for insurance. There is, in terms of the CSOS legislation, the requirements for insurance, and that is particularly insurance to cover theft or misappropriation by trustees or agents. And I will look into that in a few moments. But we need to be aware of it, and we also need to be aware of the need to have indemnity insurance, which would cover those things which are not covered by the Fidelity Fund, such as professional negligence, etc. And that kind of professional insurance is necessary in case you have some sort of mistake or error which causes you loss as a result of the managing agent's actions. Thank you very much. I think that's covered that section. Back to you, Vin.
We saw a question regarding that specifically, where there was negligence on the side of the managing agent. But as you said, we are going to deal with that a bit later on in the presentation. So the next point that I wanted to make was that there needs to be a thorough vetting of your managing agent, a proper due diligence that needs to take place, checking of references, checking of track record, checking of the financial stability of that managing agent, to check where these directors were previously, because I mean the managing agent that we are talking about now, without naming it, those people actually came from a previous managing agent where a similar matter happened as well, and also a huge amount of money was lost. So trustees must take that responsibility, and owners must take that responsibility to make sure that they vet those managing agents. But you've got the specifics in that regard, Deborah. Deborah,
yes.
Are you there?
Sorry, I just lost you for a moment. The last.
Okay, no problem. No, I was just saying you can go into some specifics in that regard.
Okay, thank you very much. All right, we've dealt with the requirement of a fidelity fund, which obviously is important, and that's the first question which you need to ask. Please be aware, ladies and gentlemen, that a managing agent must have a fidelity fund which is valid and current and was valid and current at the time which the loss arose for you to have a Fidelity Fund claim. And so you need to check that on a regular basis. Managing agents now get issued with a Fidelity Fund certificate for a 3-year period. You must ensure that it is renewed when it becomes due. Currently, the PPRA is only now beginning to issue managing agents with a Fidelity Fund certificate due to delays in implementing the Act. And so what the Property Practitioners Authority has done instead is it has used Section 4 to grant exemptions from the holding of a Fidelity Fund certificate in order to operate lawfully. That exemption is a Section 4 certificate which your managing agent should have been issued with, and on the basis of that, you would be covered by the Fidelity Fund. So that is authorized specifically by Section 4. So do ensure that if your agent doesn't have a Fidelity Fund certificate, that he does have an exemption, and that exemption has not expired, because it is provided for a limited period of time. So it needs to be renewed. Alternatively, a new Fidelity Fund certificate has to have been issued to him. Another important aspect is, do all managing agents need a Fidelity Fund certificate? And the answer to that is yes. Fidelity Fund certificate or Section 4 exemption. The next question is whether they need to have a trust account. And this is very important. The answer to that is no, if they have obtained an exemption under the provisions of the regulations, and that is Regulation 2, which allows certain property practitioners not to have a trust account, or alternatively, if the Regulation 2.6 provision applies to them. So what is the Regulation 2.6 provision? This is the provision which says that a managing agent is not required to operate a trust account if his client is a body corporate, where the funds of the body corporate are held by the body corporate itself in a bank account in the name of the body corporate, which is opened in terms of Section 21(4)(a) of the Sectional Title Schemes Management Act. So if the managing agent only deals with body corporates, then he will not have a trust account. If he does have a trust account, the funds of the body corporate need not be placed into that if they instead go directly into the body corporate's own account as specified. So that's important to know. But those are the only circumstances under which a managing agent need not have a trust account. If he takes trust monies into his own account, he must have a registered trust account, which is not only a trust account with a bank, but that it is registered with the PPRA so that we are aware of it. Also, we need to be aware of the need to do due diligence in respect of our managing agents. Check also, and you may need to from time to time just contact the PPRA to establish this, and the call center will be able to give you the information to ensure that the managing agent's FFC has not been withdrawn, he hasn't been disqualified, or he is not doesn't have outstanding audit reports. This is crucial because the audits of his trust account, as required by legislation to be submitted to us, are your safeguard that his trust account is being run properly. Right, thank you very much.
Deborah, can I quickly also just jump in here and maybe get your expertise in this regard? And maybe we must just explain to people the difference between a managing agent and an estate agent and the differentiation that has now occurred under the new Act, because it seems as if there are still lots of people that believe that you need to be an estate agent to be a managing agent and don't understand that there's now a difference between those professions, and that the requirements in respect of estate agents are not applicable in respect of managing agents.
Yes, it's actually something you can do a webinar on all on its own.
Okay,
we'll
do that.
Difficult, but I need to just explain briefly for now.
Okay,
the Act defines what an estate agent is, and the Act defines what are property practitioner activities. So you will find that if you look at the regulations, there is an indication of what your estate agent does, and that is a property practitioner activity which is limited to selling, buying, renting obtaining the rental, sending the money back to the landlord, and those kinds of activities. Their mandates are specifically directed to that. The Act and the regulations are very unhelpful when it comes to what a managing agent does. It says a managing agent includes this and that and the other thing, but that doesn't actually tell us what the managing agent's activities are limited to. We do know that the Act says that a managing agent is anybody who manages any property or any right, title, or interest in that property. So as far as that definition is concerned, we're going to undoubtedly get some case law in due course as to how far that definition goes in relation to manage. What does it mean to actually manage? Since we don't have a definition for that, we have a traditional approach, which has really been considered and accepted in our law, and that is that the management on behalf of somebody else for a fee. And if you look back at your definition of a property practitioner, you will see that there are a number of criteria which create a property practitioner. And that is someone who holds themselves out for the acquisition of game, either for their own accounts or in partnership, as a person who, on behalf of somebody else, performs certain activities. And so your managing agent is the person who performs managing activities on behalf of someone else in that scenario, in order to obtain fees, in order to obtain commissions or whatever it may be. And that operation is done in managing either the right, title, or interest in an immovable property. So that's basically what a managing agent does. And we've often had issues where people say, well, we call ourselves a managing agent and this is what we do. The fact that you call yourself a managing agent doesn't mean that you are in fact one for purposes of the Act. You need to look at what you actually perform, and if you perform those practices or those operations as described, then you will fall into the category of a managing agent, irrespective of whether you call yourself.
Perfect. And that person would then be able at this stage to obtain an exemption because we don't have those requirements in place and we don't have the educational framework in place currently, but as soon as that is in place, they will have to be compliant with that educational framework. And
yes, let me just explain that a little more, Willie, because it's a little confusing. There are two kinds of exemptions which a managing agent will have to get. Currently, we only get one exemption for a managing agent, and that's because we can't give you a fidelity fund certificate. So what we do is we say, here's the E1 form, which you find in the regulations. Please take that E1 form, send it to us, and you will see that we have already populated it with the section 48 and 49 of the Act, which you are exempted from, which means you can operate without a fidelity fund certificate. And this effectively stands in the place of a fidelity fund certificate. At the moment, your education requirements don't come into it. This is simply because we cannot give you an FFC. Now that hopefully is going to change from the end of this month, and they are starting to issue managing agents with fidelity fund certificates. When that happens, your application comes in for a fidelity fund certificate, and we will then give you an exemption from the education requirements of Regulation 33 in order to be able to issue you with that fidelity fund certificate. So the reason for that is that we don't yet know what the regulation requirements are going to be for education compliance for a managing agent. And so that's why we give you an exemption and we say, you can't yet comply with having written a managing agent PDE exam. You can't yet comply with the minimum standards of training because we don't know what they are and they're not yet available. So therefore, we will issue you with an FFC, which is a valid fidelity fund certificate, on the basis that you don't have to comply with that for the moment. So that's
and can I just also then just add, I mean, currently the industry is working, so CSAS, the PPRA, NAMA, and other parties are working to create that framework, and that hopefully will be in place soon.
That's correct.
Yeah.
Yes.
So that
yes.
people just understand that as well.
That's
All right.
correct,
The next thing that one needs to do is have a robust contract. So I was at a managing agency yesterday, and the contract is such that the managing agent can actually operate that bank account, which is in the name of the body corporate, without the trustees giving any input or having any control over it, and as such, they will have a problem because it's not a trust account and they don't have any controls in place in respect of that. And that is in terms of the contract that is in place. So one needs to make sure that you've got a properly defined contract with duties and responsibilities, and make sure that that contract actually falls within the category of account that you're going to have, so that if you have it in your own scheme's name, that you actually have the control. So I think that is the next point that I wanted to make, is about the robust contract. But I mean, you can take us further in respect of that.
Thank you, Willie. Yes. And just on that point, I would just like to advise trustees, directors, and also managing agents themselves to check their contract on an annual basis. See whether there's any legislation which might affect your contract, which might need you to tweak it or change it or amend it by way of an addendum, etc. And what's very important in that regard, I suggest, is continuous monitoring of the managing agent's compliance with legislation or with any new case law which comes up. And in that regard, I would suggest that trustees and directors, etc., require managing agents to provide them with some sort of a synopsis on an annual basis of any changes in legislation or case law which might be applicable to their scheme. And this is very important because if, for example, they change insurance requirements or CSOS rules change, that has to be attended to. So managing agents need to be very familiar with all of that. They need to keep themselves up to date, and they need to ensure that they are diligent in assisting their clients to be contractually and governance-related compliant with the law. The other thing which I think is part of continuous and thorough monitoring of the managing agents is to ensure that managing agents do provide monthly reporting. And here managing agents should be aware that in terms of the legislation, that's the Property Practitioners Act, you are obliged to balance your trust account, all of your trust accounts, on a monthly basis. So you must have that in place. If you don't do that, it is an offence, and it is a very serious offence. It can lead to serious disciplinary action. So everybody should ensure that that is done and that those monthly reports are available in respect of your trust money. Remember also that the audit has to be submitted by managing agents annually within 6 months of your financial year end, and that is an audit of all your trust accounts. Your trust accounts have to be registered with the PPRA, and you have to audit each and every one of them. And that is in total. You cannot rely on the audit of the body corporate or the community scheme. Your auditor has to conduct a full audit on his own from the source documents in respect of all your trust accounts. And that has to be submitted to us at time. So please be aware of that. It's a way of safeguarding yourselves as well as your clients. And then just one more thing on that, be aware that it's important that you see what from bank statements, if you are a community scheme, what is actually being recovered by your managing agent. Is he receiving all the levies he should? Is he getting on to collecting levies? What is he receiving and what is he not? And is that money coming into your trust account or your own personal account where necessary? Thank you.
Perfect. Next issue that I think that we need to touch on is segregated bank accounts or the bucket trust account. I have a preference to a separate bank account where the bank accounts are segregated and the body corporate actually have control over that account, but they need to ensure that they have that control and that they have the required framework in place in respect of payments and so forth. So we would require deal signatures or a ideal releasing process where the managing agent can't do everything on its own, but it also incorporates the assistance of the trustees in that regard. And in that way, then have that control over the account and safeguard that. But maybe if you can just also, I see that we are running out of time and we're still far, far away, but there's so much to be discussed here. Maybe we can just touch on the bucket trust account again, and just like you just explain the audit process in respect of that, in respect of the whole bucket
account. Yes, thank you. I did mention to Willie earlier that the new code of conduct for managing agents is being promulgated shortly. It will go to the industry first for comment, but one of the considerations which we requested was that that separate trust accounts must be held by body corporates, by managing agents rather, for each and every one of their schemes. And that you cannot use a bucket account. And the reason for that is that we appear to have a scenario where managing agents are allowing the trustees and the scheme themselves to do an audit on their section of the trust account and then relying on that for the balancing of the trust account. And that is contrary to the legislation. It is non-compliant and it causes all sorts of problems. So we need to so we're going to request that, and obviously that's something that we'll see whether that comes into fruition. But I would suggest that certainly managing agents ensure that they have separate accounts. You cannot keep control and proper governance of money unless you do that. The other thing I just want to touch on quickly is the importance of building a relationship with your banker. And the reason I say that is because in regard to the interrogation under the Companies Act that we are currently busy with, there are 61 community schemes that are involved that have lost money as a result of that managing agent. And we have, during the interrogation, come across the fact that the bank in question cannot produce to us authorizing documents signed by the trustees which allowed the managing agents to transact. But the bank has nevertheless been allowing the managing agent to transact willy-nilly for years on those community scheme accounts. And this is a huge problem. So do ensure that you are in contact with your banker and you have checked with your banker what your managing agent is being allowed to do and what he isn't. And also bear in mind that we have had an instance where 41 bodies corporate lost a huge amount of money some years ago due to the fact that the managing agents in question forged Nedbank statements of accounts to show that the community schemes savings were intact and they were in bank accounts with bank account numbers, etc. And one of the body corporates involved changed their auditor. The auditor happened to know the bank manager in question, and he noted that some of the signatures on the forged documents were not the signature of the bank manager that he knew. He then instituted an inquiry, and it turned out that Nedbank didn't hold any such accounts and that those statements had been forged. So please be aware of that and make sure that you have some controls in place. Thank you, Willie.
Okay. I think we have touched on the regular reporting and auditing. I don't know if there's much that we can add to that. So maybe just, I think you've got one point there that you want to add to that.
Yes,
already.
yes, thanks, Willie. We've actually touched on that, the requirement for the trust account or scheme accounts bank statements to be submitted to you regularly, and the importance of verification of those, which I just mentioned. That's all. Thank you.
Perfect. And then insurance, we've also touched on that. So maybe
Yes.
if you want to touch on that again, just a couple
Thanks
of salient points.
Yes, that's very important because your CSOS legislation requires statutory insurance. And it's very important for trustees to know what it is, to know what conditions your insurance has. Do you know if you comply with those conditions? And in the case of a loss, would your insurance company pay, or are they going to repudiate your claim on the basis that you didn't comply with the conditions of insurance? So that's very important. Remember that your fidelity fund will not pay if you are in breach of your statutory obligations. If you're a community scheme and you're subject to the CSOS Act, Regulation 15 of that Act applies to you. And in terms of that regulation, every community scheme must insure against the risk of loss of money belonging to the community scheme or for which it is responsible which is sustained as a result of any act of fraud or dishonesty committed by an insurable person. So please do not think that this is lumped in with your ordinary insurance. It is not. Most of your ordinary insurance contracts specifically exclude loss due to fraud or dishonesty. So you need to ensure that you have a specific insurance policy for this and that it is sufficient. And in fact, if you look at the regulation, you will see that it has to have a minimum value. And you must ensure that that minimum value is complied with. Okay. Be aware of the fact that your risk of loss is very wide and that you are responsible for that. And the fraud or dishonesty which is applicable can be of any kind. It can be forgery, doesn't have to be theft. And as a result of that, you need to ensure that your insurance covers you for all of those. Thank you.
Perfect. Banking controls, next one. Strict banking controls, make sure that you get your bank statements. I saw there was a question in that regard where managing agents don't want to provide bank statements. The mechanism of the Act is very clear that if the managing agent does not want to comply with the instructions of the body corporate or that is then represented by the trustees, then the body corporate should start putting processes in place to actually terminate that contract, because at the end of the day, you need control, or you need to see, you need to have oversight. If you don't do that as a trustee, you are not complying with your fiduciary duties. So from that point of view, trustees should then start taking action if they see that the managing agent does not want to give them bank statements in respect of their scheme. And that should be a red light. I mean, I can't understand why that information would not be made available. Deborah, your points that you wanted to make under here.
Thank you, Willie. Yes, I couldn't agree more. And you'll see a little bit later, but I'll deal with it now. I mentioned, is the tail wagging the dog? Is your managing agent telling you what you can and can't do? Please be aware that that is simply not acceptable. You are the client and you decide what agreement you have with him and what mandate he has. So please be sure that you have access to documents, that you can obtain source documents, and that you can be aware of who the managing agent's auditors are and any changes that occur in that regard. Thank you.
Next. Something that I was dealing with was budgetary oversight. Obviously, one needs to have your budget in place, and trustees need to spend in accordance with that budget, and they must make sure that there is adherence to that budget. So something that we practice in our business is that we have a budget, and when we spend money, we have an actual against what was budgeted. So one always knows if you are within your budget, can you spend that money? Can't you spend that money? Because at the end of the day, that is also a way of money that is going down or being lost. If money is spent on expenses where it wasn't budgeted for, or you're overspending on specific items, and you need to know that you're overspending to make sure that you are following the budget as was approved by owners. So that is also an important aspect. Then the next aspect that I'm touching on is trustee involvement. I think we've touched on it a couple of times now. You've said don't let the tail wag the dog. Trustees must be actively involved. They must have a financial oversight. And it's always important for them, if they don't have the financial know-how and expertise, that they bring somebody on board that actually can assist with this and actually know a bit about finances, so that one can go over that. I mean, we as Confiance in one of our subsidiaries where we administer schemes are going through audits, and we actually have a chartered accountant that sits with us, that is employed by that business, to go through that with the auditors to make sure that we understand exactly what goes on. So one needs to understand that, and there must be involvement by the trustees to do that. The next aspect that I'm touching on is transparency. We hear a lot about transparency and what should and should not, and what can and can't be given. But in general, one would want to open as much as possible to owners, so that people can see that the levies are utilized correctly, and that money is there where it should be. And as such, we encourage access to financial documents as far as possible, and that you need to have regular meetings and regular feedback to owners in respect of what's happening in schemes. Deborah, you've got a couple of points here as well.
Thank you. Yes, yes, I certainly would agree with those points. And in this regard, have a look at your MOIs, your management rules, and check that they are compliant in relation to transparency and openness and access for owners in compliance with those which are set out in the legislation of CSOS. We note that the Ombudsman, particularly in the CSOS Ombudsman, is becoming more and more aware of the need for managing agents and boards and trustees to actually make themselves available and to be transparent and to allow access to certain items and certain documentation by members who obviously have the right to protect their own property and their own investment. Of course, we don't want a situation there either where you've got one particular owner who makes it impossible for the managing agent or the trustee to do their work. And you do on occasion get that. But by and large, be aware of the fact that being accessible, being open, avoiding being unnecessarily officious is something which generally works a lot better than trying to use a stick as opposed to a carrot approach. So,
absolutely.
yes.
And we are seeing that there are court cases now coming out. There was one, I think, 2 weeks ago, a week and a half ago. We have written an article on that, so that is going to go out shortly. But there is definitely a balancing act. One can't also, just as you say, just open everything to everybody the whole time, because then the managing agent and the trustees will never get to actually doing their job. But there is a level where owners should be able to see and make sure that things are done appropriately.
Correct. Thank you.
Next one, regular meetings. Definitely important to have those meetings. Make sure that trustees are meeting, that they are checking, that they're checking the monthly management statements, make sure that they see the bank statements. So it's very, very important that those meetings are held and that people actually are conducting oversight, and that it's not just left for months on end. And I think this is here where you said the dog shouldn't wag the tail.
Yes, yes, absolutely. Thank you. And I think that just to touch very briefly on the whole mention of draconian management contracts, especially some of your very big managing agents, I'm inclined to give you an epistle of a contract which is 2,000 pages long, and rely on the fact that you're not going to read it because it's just too much trouble and you probably won't understand it anyway. If you get one of those, do get somebody who has some ability to read legalese, to just go through it and check what it is you're actually signing away your life to. So be aware of that and ensure that you do take control where that contract has to be enforced. Thanks very much.
Okay, the next one I'm saying that one should do is implement policies and procedures. So that is also important to know exactly what the policy and procedure is in respect of payments, in obtaining quotations, in authorizing work to be done. So have those policies and procedures in place in respect of your scheme. I know that some schemes always want 3 quotations. It's not always possible to get 3 quotations because people start charging money to go out and do quotations. But have those policies and procedures in place. When work starts become on the larger side, make sure that there are multiple quotations on the smaller work. Not necessarily, but make sure that you vetted your service provider, have a relationship with that service provider, but have your policies and procedures in place, and also have a payment procedure in place and making sure that that is always followed. Trustees sign off on it and they give the authority for the managing agent to make sure that that payment is then done. Also, you need to have your reconciliation process. Make sure that all accounts are reconciled on a monthly basis, that you know exactly what is going on in your account. and compare that reconciliation with your bank account and with what is in your bank account, so that you know that the money that should be there is in actual fact there. The next aspect that I'm touching on is legal action. Schemes should make sure that they can proceed with legal action where it's necessary. And you must have a protocol in place when there are problems, that you don't necessarily just run to an attorney immediately, but have that protocol in place and say, we are seeing ABC. What is the situation? Please come back to us. Tell us what the problem is. Why is this? Why is that? Have that in your policies and procedures, and know exactly how you're going to deal with it. Deborah, you also wanted to add some points here.
Yes, just to mention that you need to control the legal process very carefully, because at the end of the day, it can easily get a life of its own. And having spent my life in courts and in litigation, I've often seen it where people run away with the principles, which are expensive, which we believe we have to stand on our principles and we have to make this thing right. At the end of the day, we're paying R500,000 to recover 100,000 rand. And remember that you might get costs back, but you're not going to get your full attorney-client costs. You will only get party and party costs, and probably at least a third of your costs you're going to be paying yourself. So be aware of that.
Maybe that's something that we need to speak about again as well, is party and attorney and client cost. Yes. I mean, we at StrataFin that do a lot of collections in respect of outstanding levies know that on an unopposed basis, you can tax a account from start to finish around about 45,000 Rand. So that is your party and party fee that is recoverable from the debtor. But we see attorneys charge 120, 140. We've seen 170,000 Rand in respect of a single matter. And you can never recover that from the debtor. So that means that the scheme has actually lost that money because it has to be paid out of the administrative budget. So you're absolutely right.
Important. And the other point I wanted to make, Willie, just very quickly, is that be very careful that you're not pursuing a man of straw. There's no point in having a judgment against somebody for R1,000,000 and he has nothing, because you cannot then enforce that judgment. He has no assets to be attached. So ensure that it's worthwhile and you don't recklessly in instituting legal action, because it can end up very costly.
Then the next matter that I'm saying that is important is education and training. So trustees should educate themselves. Managing agents should educate themselves. They should understand the law. They should understand the regulations applicable. And you need to go on the regular training. I think that the new act is in any event going to make that obligatory. So there is going to be training for managing agents that are going to be required on an ongoing basis. But as you have a fiduciary duty as a trustee, you need to understand what the law says, because ignorance of the law is no defense. So you can't say, I don't know. And then, I mean, there are training available, lots of training institutions available for managing agents, and there's even free training like the StrataFin training on our training portal. So if you can't afford to have training, at least do the free training that is available. Then the next, and I think that's the last aspect that I'm touching on, is community engagement. And I see we are running out of time, so I've tried to push it a bit. Community engagement. And what we have seen is where schemes communicate and where people partake in the process, you see that things are running smoothly and people pay levies, and they're happy to pay levies because they trust. So where there's trust, you see the payment of levies and you see people partake in that scheme. So it's important that schemes engage the members, and members form part of committees. You set up your different forums. You give opportunity to owners to be part of committees, to be part of the audit committee, to be part of the maintenance committee. And the more people that are involved, the more you will see that schemes actually flourish and go forward. So those were the 16 points that we wanted to mention to assist you in making sure that your scheme runs smoothly and that monies are not being used in a way that they shouldn't be used, and that the scheme is protected as far as possible. And I just want to say thank you, Deborah. it was awesome having this webinar with you, and maybe I should take you up on the other ones. I'll ask the staff that we set that up at some stage, that we do the whole managing agent and the exemption and training and all those things as well, so that people understand the difference between what
Yes,
is
super. Thank you,
currently
Willie.
estate agent and managing
Yes.
agents.
I'd be very happy to do so. Thank you very much, and thank you for giving me the opportunity to inform everyone on these particular aspects, and do appreciate it. Thank you.
Really, really appreciate your assistance in this regard. Thanks, guys. In respect of questions that have been asked, we will answer those on email. This webinar will be available on the YouTube channel, so we will send it out to you guys, and we will answer the questions that have been asked.
We'll send out the recording. We'll send out the recording along with the questions on the same mailer. Thank you.
Thank you very much.
Thank you.